Welcome to Vermont Law School's panel on race and the law. And we're now moving to our second panel of the Voting and Politics program. My name is Brian Porto. I'm a professor at Vermont Law School, and I will moderate this panel. But the stars of the show are our three distinguished guests. They include Eric Foner, who is DeWitt Clinton Professor Emeritus of History at Columbia University. His most recent book is The Second Founding: How the Civil War and Reconstruction Remade the Constitution. Frederick Brewington is also with us on the panel. He is the principal at the law offices of Frederick K. Brewington in Hempstead, New York. His practice includes work in many areas of law related to discrimination, including discrimination in voting, which he will discuss today. And our third panelist is Patrick Berry, who is a fellow and counsel at the Brennan Center's Democracy Program, housed at New York University's Law School. One of his areas of expertise is felon disenfranchisement, which he will discuss today. Please hold your questions until all three panelists have delivered their remarks. And when you ask a question, please indicate whether it is directed toward a particular panelist. Without further ado, then, Professor Foner.
Well, yes, thank you very much. I want to thank Elijah Freeman and his colleagues for inviting me to this symposium, even though I'm far away from Vermont right now. I'm sorry I cannot see the participants, but I look forward to any questions you may have as we go along. My plan today is to speak for my 20 minutes about the history of the right to vote in the United States, and particularly African-American voting. This is an interesting and long and complicated story, but it's certainly of great relevance to the very moment we are living in. It's not widely known, I think, that during the era of the American Revolution, African-American men could vote in a majority of the 13 states that, that declared their independence, so long as they could meet the property qualification, which determined who could vote altogether. There were, on the other hand, there were very few free Black Americans at the time of the Revolution. The free Black community really begins to grow afterwards, and most of those did not have enough property to meet property qualifications. But nonetheless, most of the states did not have a racial bar to the right to vote in their laws or state constitutions. This even included some southern states like North Carolina, for example. And Black voters cast ballots in the election of delegates to the state conventions that ratified the U.S. Constitution. So they had their small but visible presence in determining if the Constitution would actually go into effect. Now, the U.S. Constitution, as you all know, begins with the words, "We the people." But it does not actually define who the people of the United States are. One might say, logically, that the people are all those living within the United States. But in fact, if you read the Constitution, you'll discover that's not the case. There are three different populations referred to in the original Constitution. One is the people. One is other persons. That means the slaves. The word slavery, of course, does not appear in the original Constitution, but the institution of slavery is there and is protected by several clauses. So we have the people, we have the other persons or slaves who are not part of the body politic, and then there are Native Americans who are dealt with via treaty, not legislation, as independent sovereignties. They are part of the people of their own nation, but not of the United States. the Constitution says very little about the original Constitution about the right to vote. Voting qualifications are left to the states. There is no national right to vote established in the Constitution, and in fact still doesn't exist 200 and some odd years later. The one thing the Constitution says is that in states where there are different qualifications for voting for different offices, for example, in a number of states, to vote for, let's say, the assembly or the lower house of a legislature, you had to have X amount of property. To vote for the Senate, you had to have more property. To vote for the governor, you had to have even more property. In those cases, the lowest qualification will apply to elections to the House of Representatives. The House of Representatives is supposed to be the most democratically selected political body. The Constitution doesn't say anything about the original Constitution about race directly, but a racial definition of American nationality begins very early. As early as 1790, in one of the first laws passed by Congress after the ratification of the Constitution and after the inauguration of George Washington, the 1790 Naturalization Act, it says only white immigrants from abroad can become naturalized citizens. To become a citizen from abroad, you have to be white. In other words, even though the founders proclaimed the United States an asylum for all mankind, as Thomas Jefferson once put it, in fact, the vast majority of the people in the world were barred from naturalized citizenship, and that kind of restriction existed for a long, long time. People from Africa were allowed to become naturalized citizens in 1870. People from Asia, not until well into the 20th century was that bar eliminated for them. But what about the right to vote? The first half of the 19th century is widely known for the spread of democracy in the United States, democracy for white Americans. For blacks, this was a period of, first of all, the great expansion of slavery, of course, but also for free black people, it was a period of losing the right to vote. State after state where free African Americans had enjoyed the right to vote, took it away in the first half of the 19th century. In effect, race replaced class as the line of division between people who could vote and who couldn't vote, along with gender, of course. No state, except for the quixotic example of New Jersey until 1807, no other state allowed allowed women to vote before the Civil War. New York State, where I live, pretty much disenfranchised almost all of its black population in 1821 when it adopted a constitution that eliminated property qualifications for whites, but increased the property qualification for blacks to $250, which was beyond the reach of just about all of them. Pennsylvania in 1837 adopted which had a very important free black community, propertied, educated, politically active. They adopted a new constitution, which again added the word white to voting qualifications, stripping from black people in Pennsylvania the right to vote. In fact, between 1800 and 1860, only one state entered the Union allowing African-American men to vote, and that was Maine. Other than that, every single state, north, south, east, and west, that came into the Union in those years restricted the right to vote to white men. By the eve of the Civil War, only 5 states, all of them in New England with very small black populations, allowed African-American men to vote on the same basis as whites. And of course, black office holding was virtually non-existent. I have only seen evidence, there may be a few more, of two African-American public officials before the Civil War, both of them justices of the peace. one in Oberlin, Ohio, a center of abolitionism, and one in Boston, I believe. And of course, as you know, the Dred Scott decision of 1857 declared that no black person could be a citizen of the United States. Meanwhile, white immigrants were generally allowed to vote even before they became citizens, even before they became naturalized. As soon as they got off the boat, they were allowed to vote in many states. This was a period, as we say, when democracy was emphasized as a defining feature of American politics and society, when de Tocqueville wrote Democracy in America, when Noah Webster's Dictionary of the English Language noted that in the United States, but not in Europe, the right to vote, the word citizen had become synonymous with the right to vote, at least for men. It was, of course, the Civil War that put the question of black voting directly on the political agenda. The end of slavery, but also the service of black soldiers in the war. About 200,000 African-American men served in the Army and Navy, staking a claim to equal rights in the reconstructed nation. In his final speech before his assassination, Abraham Lincoln said that he favored limited black suffrage in the post-war world. Particularly, he said, the very intelligent, that is the free, educated free blacks, but also those who serve our cause as soldiers. The soldiers had earned the right to vote, according to Lincoln. Lincoln had never favored black suffrage before the war, but now he was ahead of the curve. As I said, there was still only 5 states that allowed African Americans of any kind to vote. The issue of the rights of the former slaves was the crux upon which the period of Reconstruction turned, and the right to vote was, of course, a key issue and was a dividing line in the Republican Party. Moderate Republicans were nervous that they could never get amendments or laws passed giving black men the right to vote, that white society would not accept it, it would be counterproductive. Radical Republicans insisted that the right to vote was essential to freedom and was essential to making sure that the South did not fall back under the control of former Confederates. The 14th Amendment, which everybody in a law school is familiar with, I hope, barred the states, of course, from denying the equal protection of the laws to any person and denying the privileges or immunities of citizens, but it did not specifically give anybody the right to vote. It tried to encourage black suffrage in the South. At this point, all white governments were in effect in the South, established by President Andrew Johnson. They tried to encourage these states to give blacks the right to vote through Section 2, which said, although it is virtually incomprehensible, if you read it, doesn't seem to be English really, but what it basically says is, if a state denies any group of male citizens the right to vote, they will lose in proportion representation in Congress. So, for example, Alabama at that time was about 50% black, 50% white. If they didn't give black men the right to vote, they'd lose half their members of Congress. The women's movement was bitterly opposed to this because it introduced the word male into the Constitution for the first time. If women were denied the right to vote, there was no penalty. If any group of men was, states would lose representation. This has never been enforced. I have founded an organization which has at least 2 members now to try to encourage enforcing Section 2 of the 14th Amendment. There are enough states that have disenfranchised enough of their population that they ought to lose a member of Congress. Section 3, by the way, also ought to be enforced, and there's some talk of doing that now. It says that no one can hold office if they took an oath to support the Constitution and later aided in insurrection, as the President of the United States did. It's a much simpler way of dealing with ex-President Trump than impeachment, but Congress has yet to realize this. In 1867, the Reconstruction Acts, of course, gave the right to vote for the first time to very large numbers of African Americans in the South, men only, of course. Ironic, this was part of the radical Reconstruction program to create new biracial governments throughout the South. The irony here is that in 1867, hundreds of thousands of African Americans who were former slaves now could vote, whereas in the North, Black people who had been free for generations still couldn't vote, or in the border states that had remained in the Union, even though slave states. Voting for Blacks in the North basically came in 1870 with the ratification of the 15th Amendment. One irony here is that, yes, new governments were set up in the South under radical Reconstruction, biracial governments, which ratified the 14th Amendment. Without Black suffrage, no 14th Amendment. And that is just a basic fact which is ignored in most of the literature on the 14th Amendment, which is voluminous. If you want to know the original meaning of the 14th Amendment, you've got to look at what Black people thought the 14th Amendment was all about, because without their votes, it would never have become ratified. But very few law journal articles allow a Black voice into this discussion. The 15th Amendment, as I said, extended Black suffrage throughout the nation, but it had its weakness. It barred states from denying the right to vote on the basis of race, but it left open loopholes that would later be taken advantage of. Other barriers, whether it's literacy tests, poll taxes, other ways that the southern states after Reconstruction would in fact use to disenfranchise the vast majority of the Black population in the South, starting around 1890 and down into the 20th century. At that point, all the Confederate states plus Delaware and Oklahoma basically had abrogated the 15th Amendment and taken away the right to vote from Black men. Reconstruction also, of course, produced a violent backlash, an upsurge of domestic terrorism, the Ku Klux Klan and groups like that. What we saw on the 6th of January was not unprecedented. In Reconstruction, mobs of white supremacists stormed local governing places throughout the local governments, or even after Reconstruction, the Wilmington riot of 1898 in North Carolina, where a democratically elected biracial government was ousted from power by a white mob and sort of a coup d'etat. The Battle of Liberty Place in 1874 in New Orleans, an uprising by the White League to try to overthrow the government of Louisiana. White supremacist mobs seeking to overturn democratic elections are not necessarily new in American history, although most of the commentators on January 6th seem to think that that was the case. It's also worth mentioning that the disenfranchisement, which followed Reconstruction, was given its imprimatur by the Supreme Court in cases such as Giles v. Harris in the early 20th century. The Supreme Court just threw up its hands and said, look, this came out of Alabama. If the white people of Alabama want to take the right to vote away from Black people, there is nothing we can do about it. This was Oliver Wendell Holmes just beginning his distinguished career as a member of the Supreme Court, but this was certainly one of his less appealing decisions. In 1920, the 19th Amendment was ratified, adding sex to the qualifications that could not bar you from voting, women's suffrage. Ironically, these two great expansions of American democracy, the 15th Amendment giving Black men the right to vote, the 19th Amendment supposedly giving all women the right to vote, both of those expanded democracy but left Black women pretty much off to the side. The 15th had nothing to do with women. It was all about race. The 19th did not change the laws of the southern states, which, without mentioning race, actually disenfranchised the bulk of the Black population. So Black women in the South did not actually get the right to vote until the 1965 Voting Rights Act. But because of the Great Migration of starting in around World War I of blacks from the South to the North, where the right to vote was respected, African Americans now began to become a significant voting bloc in northern cities. The last post-Reconstruction black congressman, was George White from North Carolina, who left office in 1901. For the next 25 or so years, the House of Representatives was all white until Oscar DePriest was elected from Chicago with a very significant black vote, enabling him to get into the House of Representatives. The first black member of the House of Representatives from a Confederate state was Barbara Jordan, not elected until 1972. Now, I'm going to finish up in a minute here just by pointing out what everybody here knows, that the right to vote is still very, very bitterly contested in our country today. Voter suppression is taking place in a number of states, particularly directed at those groups that are likely to vote Democratic, whether it's African Americans, Latinos, or others. The Supreme Court, as it had 60, 70 years before, gave its imprimatur to this in Shelby County versus Holder, which eviscerated the Voting Rights Act of 1965. Whether it's gerrymandering, whether it's ID requirements, whether it's simply closing voting places in minority communities, efforts to restrict the right to vote are certainly taking place today, although not necessarily with great success. The recent presidential election had a very high turnout, had the highest turnout in a long, long time. I got the impression that a lot of voters came out to vote on the theory, use it or lose it. In other words, that the effort to suppress their vote actually got them out there to try to exercise it. But nonetheless, even right today, measures to limit the right to vote in one way or another are pending in quite a few state legislatures. On the other hand, there is a bill now pending before Congress which will enhance the right to vote, which will sort of try to create more uniform standards throughout the country. Because one of the peculiarities of our system, as you all know, is there are 50 different qualifications for systems of qualification for voting in the United States. Different states have different qualifications. You can lose your right to vote simply by moving from one state to another, which is absurd in a modern national democracy. So what are the lessons of this very abbreviated and quick look at the history of African American voting? One, white supremacy, or efforts to enforce white supremacy, are deeply embedded in our history. They are not something that just popped up in the last couple of years. Two, our rights cannot be taken for granted. Our history is not a straight line of greater and greater freedom, as it is sometimes portrayed, but in fact a much more complicated series of ups and downs. So I will just leave with the following sentence, which is the lesson of all this. Rights can be gained and rights can be taken away. So thank you for listening.
Professor Foner, thank you very much. We will now turn to Mr. Brewington.
Thank you. And Professor Foner, awesome presentation. Thank you so much for bringing us through that very important history in a very short period of time. I was wondering how you were going to do it, and you did it amazingly. First, let me also say thank you to Elijah Freeman and for the offer to come and speak with you this afternoon about the voting rights issues and the questions dealing with race and the law. I'm going to talk to you a little bit about a case that recently was tried in the Eastern District of New York, and it is a voting rights case. For those of you who don't know me, I'm an attorney that does civil rights work, and have been doing civil rights work, and including voting rights cases over a number of years. One of the cases that you might want to take a look at is Gooseby versus the town of Hempstead. But today we're going to talk about Flores versus the town of Islip, which is another component of a disenfranchisement that Professor Foner was speaking about, which deals with the at-large voting systems and the Voting Rights Act of 1965, which deals with those things which may very well impede the ability for noticed and clear minority persons to be able to elect candidates of their choice. So I'm going to start by sharing my screen and see if we can start to get in to some of the aspects of this voting rights case. Let's see if we can do that. There we go. And I'm going to introduce you to Flores versus town of Islip in the Eastern District of New York. This is the CV number. And I'm going to be taking you through a little bit of this case to talk about an actual case that was brought and recently tried. We concluded the trial in this case in October of 2020, and we did it virtually. It is a case that was tried before a judge, Judge Brown, Gary Brown of the Eastern District of New York. And I'm going to take you through the case so that you can understand the application of the Voting Rights Act of 1965 in this context, as it has been used both in the South and then more recently, historically, in the North. And I point you to Gooseby, Goosby, versus the town of Hempstead as being one of the grandmother cases of the Northeast. Our little disclaimer: the right to vote, and this is from Reynolds versus Simmons, and I'll ask you to please take a look at the year 1964. This was just before the Voting Rights Act was actually enacted, but it says that to vote freely for a candidate is one's choice is the essence of a democratic society. And that was the context under which we proceeded in the case of Flores versus the town of Islip. This was referenced before by Professor Foner, that being the Voting Rights Act, and it is a much more in-depth act than is on your screen in these two slides. But we wanted to talk to you about Section 2 of the Voting Rights Act, as amended, which establishes that no vote qualification or prerequisites to voting or standard or practice or procedure, such as was mentioned by Professor Foner, like poll taxes, like literacy tests. And we also see that with regard to, and we're going to hear some of that with regard to our brother Patrick Berry is going to talk to us a little bit about one aspect of other forms of disenfranchisement. But this is the section under which we litigated both Gooseby and the Flores case, because it dealt with the denial or abridgment of the right of any citizen in the United States to vote on account of their race. This is the other sections. And we won't dwell on trying to get too much into the language of them, but it is important for us to realize as we look at this that that the Voting Rights Act has been and continues to be under attack from a legislative standpoint. In fact, we saw Section 5 being basically dismantled. While Section 2 remains in place, it still requires a very high level of proof to be able to satisfy what is required by this act of Congress. Plaintiffs required to satisfy three preconditions. One, the minority group must be sufficiently large and geographically compact to constitute a majority in a single member district. Well, why is that important? Well, it's important because when we talk about at-large voting, we are talking about voting where there is a large, either geographic body or politically a political geographic body that has in it a number of seats that can be elected for that large geographic group. But in a at-large system, there are no districts, just like we have congressional districts and senatorial districts. It'd be as though someone ran for Congress but didn't run in the first congressional district, but just ran nationwide and tried to get elected by a nationwide vote. Well, the same thing was happening in the town of Islip. In Islip, while a very large geographic area, there were no districts. But each time that a minority person, particularly a Hispanic person, ran, they would lose because their vote would be diluted. In other words, their vote, even though they voted very strongly for a candidate of their choice, who might be a Latino, that person would lose because that vote that they voted concentrated would get lost in the larger white vote due to a phenomenon referred to as racial bloc voting. So what's the second one? Two, the other precondition set out by Congress is that it must be politically cohesive. In other words, they've got to work together, vote together, be able to pull themselves together politically. And three, that the white majority must vote sufficiently as a bloc, white racial bloc voting, to enable it, in the absence of special circumstances, to defeat the minority's preferred candidate. And there are a series of cases, but Thornburg versus Jingles, the citation is here, is one of the leading cases. In Islip, we had four plaintiffs, individual plaintiffs, and here they are: Anna, Renee, who's actually her father, Maria, and Magali. These individuals stood as representatives for a very large and identifiable Latino community in Islip, on Long Island in the state of New York. And these individuals were joined by two organizations. One, New York Communities for Change, and Make the Road New York, who served as plaintiffs from the standpoint of being organizational plaintiffs. So where is Islip? Well, those of you who may not know your geography well, let me just point you. This is part of Long Island. Nassau County is to the west, and Suffolk County, and you've heard of Long Island. Well, this is the long part of Long Island, goes out eastward. This body of water is the Long Island Sound, and this is Connecticut, where you see my arrow. And out here is the Atlantic Ocean. Going to the left of this screen would be going toward the mainland and toward the Bronx and New York City, as we look at this geographically. This is a tighter view of the town of Islip, and there are other towns around it on Long Island. This town of Babylon, Huntington, Smithtown, Brookhaven. But in Islip, you had many communities, and these were in this town. These were villages, and some of them are known as census designated places, or CDPs. These areas were designated both by the census and or their geographic boundaries, such as West Islip, Brentwood, Central Islip, Holbrook, and you can see these on this map. Each of the current town board members and where they live is indicated on the following map. And we point this out because this points out to where these individuals lived, to show that the Latino community, who are our plaintiffs, did not have the ability to elect the candidate of their choice, and in fact had no one that lived in their community to look out for their needs. This is the town again and all the villages, but if you'll see, the supervisor, who is essentially like the mayor or like the head of the board, as well as the four board members, all lived south of a major thoroughfare known as Sunrise Highway. And we're going to get to what this map represents as we go forward. But if you'll see, none of these individuals were even close to the community that's darkened here. We worked with a number of experts in this case, Andrew Beveridge from Queens College, Dr. Michael McDonald, who served as a wonderful racial bloc voting analysis expert. But these are some of his words. Under conditions of polarized voting, and more especially conditions involving enhancing factors such as a designated post, a small council size, and off-year timing, at-large elections can silence the minority voices. Those conditions are present in Islip, and so is the silence of Latino voters' choices of representatives in the town council. I wanted to show you how things developed, because we could not bring this case up until about the time that we did in 2018, because the Latino community was not cohesive and large enough to form a single member district. So in 1980, as you follow these screens I'm going to show you, you will see that there was a recognizable amount of individuals that were Latino, but not very large in terms of the total population. And here's your measure here. But in 1990, it started to get more prominent. 2000, you see the areas becoming more dark, according to this chart, where it was 70 to 80% Latino. And then when we go to using the ACS, which is a calculation which is done before the actual 2020 census, you will see that the Latino community was very large, particularly in Brentwood, North Bayshore, and Central Islip, the concentration, and then further pockets. But the other parts of the community remained unaffected by this population, which is being concentrated into a geographic area. And down here, by the way, this is the water. We learned in this case that there has never been a non-white town board member in Islip's history. Stop for a second. This is New York on Long Island. There had never been in the town of Islip a person of color that was elected to their town board ever. And we went back and just pulled up from 2005, and we found that Islip town board members since 2005, and this is what the roster looked like. There was no person of color. There were a few women, but in this situation, you will see that it was predominantly white men, and all, except for one, Miss Green, lived close to the community back in 2005, but all of them lived outside of the affected and impacted community of the Latino population. So we looked, and this is what the map showed us. The map showed us that the concentration in Brentwood and North Bayshore was intense. In Central Islip, it was strong, but not as strong as in Brentwood. And if you look at the legend here, that shows you that. And what we were able to do was take a very close look at what was going on in here, that being in these communities as compared to, for instance, someplace like Great River or Oakdale or Sayville. We saw that from 1970, where the Latino community was approximately 3.3% of the population of the town of Islip, that coming into 2014 and 2018, that they were nearly 1/3 of the total population in the town. So this shows the Latino population in Islip town and CDPs and villages. CDPs, remember, these are census designated places. And you will see, again, the concentration in more detail by blocks and by districts. Another way of looking at this is to see where there are no or very few Latinos, and this is the non-Hispanic white population. And you'll see the very dark areas here represent the white population as compared to the Latino population, and you can see that there is a very segregated look to what's going on here. Yes, I did say segregation in the year 2021 because it is and remains that being Suffolk County and Nassau County on Long Island, two of the most segregated by race, two of the most segregated suburban communities in the country. Under the totality of circumstances, not only did we have to show that they were cohesive and that they voted together and that geographically compact and that there was racial bloc voting, but we had to also look at the political processes for nomination and election. Did those affect? Are equally open to participate in members in the protected class? That being political parties and how the parties controlled things. The Suffolk County Republican Party is very strong, and in Islip it was even stronger. And three, because the class members have less opportunity than others to participate and elect their representatives of choice, again, citing the Gooseby case, that becomes important as to whether or not, in other words, a court must determine whether the minority group's political power is actually diluted, that being diluted. And how do we then define that concept of dilution? Well, it's easy. You take a cup of cream, and if you were to take the cup of cream and put a spoonful of coffee in it, and then put the spoon and stir the coffee, you would see largely the cream. That means the vote, being the spoonful of coffee, would be diluted. This chart shows student population in those districts. And if you'll see, the communities that I spoke to, Brentwood, Islip, and Bayshore, largely segregated. That being the Latino community and the Black community together, showing where large parts of the Black and Latino communities were being schooled as compared to other communities in the school districts serving the town of Islip. Other areas that we need to evaluate what's going on in that community, the totality of the circumstances, looking at educational attainment, who owned houses and who were renters, income disparities. If you see here, large income difference between households, and unemployment. Look at the numbers of unemployment. We were able to pull that together and show that in these situations, not only were people not able to elect candidates of their choice, but because of what was going on historically and politically, the people were being disadvantaged because they did not have a full voice in government. There was one situation where there was a park called the Roberto Clemente Park, and I encourage folks to look it up on the web and evaluate the fact that this park had 40,000 tons of waste dumped in it, and it was right in the middle of Brentwood, one of the communities that we spoke about, and no one said anything. It was a town park, and no one was there. And when complaints came, no one answered those complaints because no one was elected from that district. And frankly, they acted as though they didn't care. I didn't put a caption on this because I wanted you to look at this. At the height of the first wave of the pandemic that we're in now, this shows what Suffolk County was suffering with regard to whites per 100,000 and Latinos per 100,000. 44.7 per 100,000 deaths and 93.3 deaths in the Latino community. And the epicenter of this, particularly in the New York area on Long Island, was the Brentwood Central Islip community. Also, we were able to point out and showed how racial appeals impacted the elections that were going on. And why is that important? Because we then look at what's going on in the fabric of the political system. And this is just one example where this individual who's running for county legislator from the community, that being the Islip community, and this is not the town board, but he was a town board member at the time, is talking about federal task force actions on MS-13 and tighter control of our boundaries to stop the flow of heroin and gang members. the county legislator has nothing to do with those areas, but yet this was his focus of his campaign literature, making a racial appeal. The time of suffrage can be denied by a debasement or dilution of the weight of the citizen's vote, just as effectively as by wholly prohibiting the free exercise of the franchise. And we know, based on Professor Foner's discussion with us earlier, that the 15th Amendment did not do the trick. It didn't serve to do what it was, at least on paper, intended to do. But in reality, what it did was it did create other barriers, such as at-large voting systems, poll taxes, literacy tests, and other tests that were put up as barriers that were just unfair. Well, the at-large voting system was just another one of those, and it served to basically prohibit the free exercise of the franchise. Outcome: Long Island Latinos win a major settlement in federal voting rights case. We settled the case during my cross-examination of the town supervisor. We were cross-examining her in the morning, and at the break after the morning session, we were asked, could we talk settlement? And we then did enter into a settlement, which created districts in the town of Islip where none ever existed before. And currently, they are preparing to select candidates to run in the 2021 election pursuant to our settlement agreement for districts for the first time in the town of Islip. And this was done under the Voting Rights Act for a community that was underserved and underrepresented and most certainly disrespected. And that work continues throughout the country. Through the Legal Defense Fund of the NAACP and other organizations, the Brennan Center are doing remarkable work to try and address issues of disenfranchisement, along with lawyers like myself and our team, Randolph McLaughlin, some very young, great lawyers from Paul Weiss that served as a team together to bring this sense of justice to the people of Islip, and particularly a community that was crying out for justice. So I'm going to stop sharing at this point. Let's see if I can come out of this. And let's see if I can get rid of that. And let me just end by just stating that in this case, one of the most important things was to make sure that this community knew that their votes did and would count. They had been fighting hard. There had been elections held where Latinos did run and lost. They lost every time, even though if there were districts, they would have won. So this is another way of dealing with voter disenfranchisement, and a way that can be done with litigation. And just so you know, this was not an easy battle, but if indeed we're trying to make a difference in our world, none of it's going to be easy, because it wasn't created for it to be just overcome easily. And I thank each of you for listening and paying attention, because in this discussion, one of the things that I find is very important is that there's much work yet to be done. I thank you very much for your time, and I look forward to hearing the rest of the lecture.
Mr. Brewington, thank you very much. Before we move to Mr. Berry's presentation, I just want to advise the viewers that they could use the chat icon to ask questions that will be reserved for our Q&A session. So you can write your questions now, and they'll be put in the archives, if you will, and held until the Q&A time. Mr. Berry.
Hi, everyone. My name is Patrick Berry. I'm an attorney at the Brennan Center for Justice. Thank you again for inviting me to join you all today. Both were two tough acts to follow, but let me get set up. Just 1 second. So I'll start with just a bit of background about the Brennan Center. We're a nonpartisan law and public policy institute that seeks to improve our systems of democracy and justice. We're a hybrid organization, part think tank, advocacy group, public interest law firm, and communications hub. And our work in each one of these areas supports and strengthens our work in the others. On the Voting Rights and Elections team, we advocate for proposals to expand access to registration and voting. We also file lawsuits to block restrictive voting laws that make it harder to vote. One of the issues that my work focuses on is felony disenfranchisement, which is what I'm here to talk to you about today. As many as 5.2 million Americans are barred from voting because of a felony conviction, nearly 1 million fewer than in 2016. Most of these citizens are no longer incarcerated. They're home, working, paying taxes, going to school, and raising families, yet they're not allowed to vote. In fact, only 25% of people disenfranchised are in prison or jail, while 22% are on felony probation, 10% are on parole, and the remaining 43% are people who have completed their sentences but still can't vote. These voting bans disproportionately affect Black Americans. Nationwide, 1 in 16 Black adults are disenfranchised because of a felony conviction, and in some states, the rate is much higher. In Wyoming, for example, more than 36% of Black voters are disenfranchised because of a felony conviction, and in Mississippi, the state with the highest disenfranchisement rate overall, it's about 16%. Latino Americans are also disproportionately impacted. Over 560,000 Latino Americans, or over 2% of the voting eligible population, are disenfranchised because of a felony conviction. There's a deep and troubling history of racism driving felony disenfranchisement laws. After the Civil War, states passed these laws to bar people with criminal convictions from voting. These were in addition to other voting restrictions, such as poll taxes and literacy tests. And as these laws spread, states began creating lists of crimes they believe were most likely to impact Black voters. Additionally, states with a higher proportion of Black residents were more likely to pass harsher restrictions, and these laws were not limited to the South. At the very time that the 14th and 15th Amendment forced New York to remove its property requirement for Black voters, the state changed its law from allowing to requiring felony disenfranchisement. California's Constitution from 1879 provided that no native of China, no idiot, insane person, or person convicted of any infamous crime could vote. And just 9 years before that Constitution was adopted, the state refused to ratify the 15th Amendment. As you can see from this map, felony disenfranchisement laws vary widely across the country. 18 states bar people from voting only while they're in prison. Those states are light blue on our map. On the other hand, Vermont, Maine, and Washington, D.C., noted by being dark blue on our map, never take the right to vote away, meaning people in prison can vote. The remaining 30 states fall somewhere in between, forming a very, very, very confusing patchwork of laws. Some states prohibit people from voting while they're on probation or parole, while others impose additional waiting periods or even require payment of court debt. Some also permanently disenfranchise those convicted of certain offenses unless they receive a pardon from the governor. Even within a single state, the rules can be quite complicated, contingent on things like the date and type of a crime a person was charged with. Alabama, for example, has prohibited people convicted of crimes of, quote, moral turpitude from voting since the 20th century. But until 2017, the state never explicitly said which crimes amounted to ones of moral turpitude, giving local election officials wide discretion to block people from voting because of different crimes. Few people also know the difference between parole and probation, yet in 3 states, Connecticut, Louisiana, and New York, people on probation may, those on parole may not. Connecticut's law is made even more confusing by the fact that only people convicted of felonies in another state or in a federal court are required to pay outstanding court debt before they can register, but those convicted of a felony in a Connecticut state court are not. Election officials also receive little or no training on these laws, and there is little or no coordination or communication between election officials and the criminal legal system. These factors, coupled with complex laws and complicated registration procedures, result in mass dissemination of inaccurate and misleading information. This confusion has real consequences. In rare cases, it can lead to people being prosecuted for mistakenly voting despite being ineligible to vote. Perhaps the most notable example of this happening is Crystal Mason, a Black woman in Texas who was sentenced to 5 years in prison for illegally voting, even though she didn't know she was ineligible, and her vote ultimately was not counted. More commonly, however, this confusion results in the de facto disenfranchisement of untold numbers of people who are in fact eligible to vote, but don't know they are, or refrain from voting out of fear of breaking the law. Even worse, the disenfranchisement of one person can also have spillover effects throughout their family and their community. In other words, eligible voters who live in neighborhoods where felony disenfranchisement is rampant turn out to vote at lower rates. Despite the damaging impact of felony disenfranchisement laws, efforts to challenge them in court have largely been unsuccessful. Richard versus Ramirez is the leading precedent courts rely on to reject constitutional challenges to these laws. And that's a case where the United States Supreme Court held that states are granted an affirmative sanction to disenfranchise those convicted of crimes. Since Ramirez, advocates have also attempted to challenge felony disenfranchisement laws under the 8th and 24th Amendments, but these efforts have largely been unsuccessful because courts, following Ramirez, have evaluated those laws under a more deferential rational basis review rather than strict scrutiny. Several circuit courts have also held that Section 2 of the Voting Rights Act, which, as you know from Fred's presentation, prohibits states from denying the right to vote to people based on their race, does not apply to felony disenfranchisement laws, while other circuit courts have held that proof of intentional discrimination, which is a very high burden to meet, is necessary to challenge these laws under Section 2. And to date, the Supreme Court has yet to weigh in on whether or not Section 2 applies to felony disenfranchisement, but that seems like it's a good thing. Challenges under state constitutions have fared similarly. Last year, a Minnesota court dismissed a lawsuit challenging the state's policy of disenfranchising people on probation, holding that the plaintiffs had not shown that people convicted of crimes have a fundamental right to vote, nor that the state lacked a rational basis to deny that right until probation periods have been exhausted. A North Carolina court, however, struck down a portion of the state's law that blocked people from voting only because they still owe court debt, holding that such a requirement violates the state's constitution because it conditions the ability to vote on one's financial means. Fortunately, there's been a growing movement among state legislators and other leaders to restore voting rights to more people with felony convictions. And as a general matter, it bears noting that this is an issue where there has been some history of bipartisan interest and success. In the last 20 years, over a dozen states have taken some action to extend the vote to those with past convictions. In 2018, Louisiana's Republican-controlled legislature passed a law that was signed into law by the state's Democratic governor, restoring voting rights to tens of thousands of people on probation and parole. In 2019, Arizona's Republican governor signed into law a bill that removed the requirement that people convicted of a first-time felony offense pay off their restitution before having their voting rights restored. 4 states, California, Colorado, Nevada, and New Jersey, all enacted policies restoring voting rights upon release from prison. And Washington, D.C. also changed its policy, joining Maine and Vermont in never taking the right to vote away. Some states also changed their policies through executive orders during that time. In 2018, New York's governor began using his pardon power to restore voting rights to people on parole. The next year, Kentucky's governor signed an executive order restoring voting rights to more than 100,000 people convicted of nonviolent offenses who had completed probation or parole. Last year, Iowa's Republican governor issued an executive order restoring voting rights to tens of thousands of Iowans previously barred from voting for life, bringing an end to the state's policy of blanket disenfranchisement. And that move by Iowa's governor also resulted to the first time in a very long time where there are no states in the United States that have a policy of blanket disenfranchisement for people convicted of crimes. Within the past 2 years, rights restoration also became part of the national dialogue, with all major 2020 Democratic candidates for president taking a position on the issue. California is the most recent state to change its policy, where voters approved Proposition 17 in November, amending the state's constitution so that anyone who's not currently in prison for a felony conviction can vote. Prior to Prop 17, California's constitution barred people with felony convictions from voting while they were in prison or on parole. As a result, as many as 50,000 people on parole, a disproportionate number of whom were black and brown because of systemic racism in the legal system, could not vote. California was also one of the very small numbers of states that excluded some people on community supervision from voting, but allowed others to vote, and was arguably much worse than New York and Connecticut and Louisiana that have probation and parole, because California has 4 forms of community supervision. Nearly 60% of Californians voted in favor of Prop 17, which also got more yes votes than the 11 other initiatives on the ballot, touching on issues from affirmative action to rent control to even rideshare apps. And in all, over 400 prominent individuals and organizations endorsed the initiative, including state and national elected officials, businesses, including even Ben & Jerry's, civil rights groups, conservative groups, faith groups, labor unions, law enforcement associations, student groups, as well as celebrities and activists like John Legend. Unfortunately, all of this progress has not been without pushback, the most obvious example being Florida. In 2018, a supermajority of Florida voters approved Amendment 4, a constitutional amendment that automatically restored voting rights to as many as 1.4 million Floridians, except those convicted of murder or a felony sexual offense who had completed the terms of their sentence, including parole or probation. Prior to Amendment 4, Florida's constitution permanently barred all citizens with a felony conviction from voting unless the Clemency Board restored their voting rights. And in 2016, more than 1 in 5 of Florida's Black voting age population was disenfranchised because of a past conviction. Shortly after Amendment 4 went into effect, Florida's Republican-controlled legislature passed a law requiring all formerly incarcerated people to pay off all their court debt, including restitution, fines, fees, and court costs before they could actually vote. At least 900,000 Floridians are disenfranchised by this new law solely because they cannot afford to pay what they owe, the majority of whom are Black. And since Florida has no centralized system for tracking whether any of this money has been paid, it's next to impossible to make eligibility determinations. Our client, Pastor Clifford Tyson, provides a perfect example of the problem with Florida's law. Despite a team of lawyers, in addition to myself, as well as hours of research by local county officials, to date, no one has been able to give him a definitive answer about how much he owes for his convictions that date back to the 80s. Along with the ACLU, the NAACP, LDF, and other groups, we filed a federal lawsuit challenging Florida's pay-to-vote law on a number of legal grounds, claiming that it violated the federal constitution. But as I'm sure you've read, the results have unfortunately been a mixed bag. After an 8-day trial, which was conducted entirely by video because of the pandemic, a federal judge held that Florida's law was unconstitutional in part. In making that determination, he found that the overwhelming majority of returning Floridians would be too poor to pay the amounts owed, and that's if they could actually find out what they owed. The judge also said that Florida's pay-to-vote law created an administrative nightmare and that it also accounted to an unconstitutional tax on voting. But the state appealed, and the 11th Circuit held that the law did not amount to an unconstitutional poll tax, barring those 900,000 Floridians who can't afford to pay their court debt from voting in November's election. Despite this setback in Florida, there's still reason for optimism. This year, 15 states are considering measures to restore voting rights or to ease current restrictions for people with past convictions. Of those states, lawmakers in Connecticut and Oregon are considering bills that would enable people in prison to vote. In New Mexico, New York, and Washington State, lawmakers are considering bills that would allow everyone in prison to vote. And in Iowa, lawmakers are also considering proposals that would place constitutional amendments on the ballot to automatically restore voting rights after complete prison, parole, and probation. At the federal level, there's also opportunity for more comprehensive reform. Congress is considering the Democracy Restoration Act, which would allow Americans who aren't in prison to vote in federal elections, regardless of whether they have a criminal record that makes them ineligible to vote in state elections. The Democracy Restoration Act is included in H.R. 1, or the For the People Act, which is the omnibus democracy reform bill, which passed the House of Representatives by a substantial margin in 2019. While installed in the Senate, it was co-sponsored by all 47 Senate Democrats, and now the new Congress is poised to advance this historic legislation. In closing, we have a lot of work to do, but if a couple of years have been any indication of where they're going with regards to this issue, I am feeling optimistic. Thank you again. Happy to answer any questions.
Thank you, much appreciated. We do have some questions in the chat. The first couple of questions are for any of the panelists who want to take them on, and I'm not certain of precisely what they're asking, so I may need to guess a little bit. The first one asks, what problems do you envision arising if our government adopted electoral college votes based on population? I'm assuming that means if we replace the popular vote, which is not exactly what you folks were talking about, but anybody want to take that on? And related to that is, should there be a constitutional amendment toward that end?
I would respond. It is a little unclear what's being asked, but
Yes.
I think the Electoral College is unsalvageable, so to speak. What's wrong with it is not going to be changed by changing how electoral votes are allocated, etc. It's a relic of the 18th century, of a period when the political leaders simply didn't trust the intelligence of ordinary people and didn't think they had the capacity to directly elect the president. So they were supposed to vote for local notables who would be better equipped to do that. It gives extra strength to small, underpopulated states because every state begins with the 2 electoral votes represented by their senators. So, my view is the electoral vote needs to be gotten rid of. It can't be, because the states that benefit from it are not going to approve a constitutional amendment. But if it were possible, I think it would be very desirable to just have a popular vote where the person who gets the most votes wins. We don't seem to have that necessarily at the moment.
All right. Does anybody want
to have anything to
weigh in on that? Anybody else? I've always wondered, just as an aside, after what happened in 2016, I would have thought if the Electoral College worked and actually was valuable, some elders would have stepped in and prevented what happened in 2016, but it didn't seem to do that, and therefore seems to me maybe that takes away any possible justification for it. But in any event, I'll move on to other questions. This one I think must be for Patrick Berry. Do felony disenfranchisement laws affect the outcome of votes? And if so, how can that situation be improved?
Sure.
Again, I'm not entirely certain what's being asked.
Or the question is whether voting rights to people because of a conviction.
The question asks felony disenfranchisement laws affect the outcome of votes? In other words, I guess, are the disenfranchised felons likely to vote one way or the other consistently?
So certainly, I don't think that if people that are disenfranchised because of a conviction were able to vote, that they would all vote in one way. But I do think that there are certainly elections that have been, decided on a very thin margin. If people that were disenfranchised were able to vote, the outcome of the election could have changed. There are a number of people who say that's true of Florida. In Bush versus Gore. With regards to how things can be improved, I'm certain, and this is just in my personal opinion, never taking the right to vote away would be a major improvement. But the second best is certainly allowing anyone who's not in vote. That's a clear blind rule that everyone can understand. As I was saying during my presentation, election officials don't understand, complicated criminal sentencing laws. Many people don't know that there's a difference between prison and jail. And so bright line rules, in addition to a ton of public education around this issue and what the impact of a criminal conviction has on someone's eligibility to vote, would be a major improvement.
Do you think that probation or parole should play in here? That the disenfranchisement should end when not until the person has been off probation or parole, or just end when he or she comes out of prison?
So I think you can look at states like New York, Connecticut, and Louisiana and see that such a distinction between probation and parole isn't meaningful. Everyone who's on probation or parole has been deemed fit to live in the community, and there just simply isn't any valid criminal legal, purpose for denying someone's voting rights. And for that reason, there's just a significant amount of support restoring voting rights upon release from prison, in particular, among correction officials, law enforcement, survivor groups, and other criminal justice reform coalitions, because they recognize that there's no benefit to denying someone their right to vote. You just further marginalize them. Whereas when you allow people to vote, you're giving them a stake in their community, and you're encouraging them to interact with their community in a very positive way. So I don't think that there's any distinction between probation and parole. That was a very long answer to your question, but yeah.
Oh, that's fine. That's fine.
Professor Porto,
So,
I mean, one of
yes.
the things that we also have to discuss in there, I mean, Brother Barry was answering a very specific question, but that begs the question of whether or not the rights should be taken away in the first place, and whether or not individuals, right? I mean, so I think that we need just to, because once those rights are taken away, we start to dampen the person's ability to fully participate in the democracy. And whether or not, I mean, if they're doing time and they do 2 years, they've been punished. If they, but taking away their right to vote or to be part and have their votes counted during the time that they are imprisoned is a question in the first place.
Let me see. I think we have time. Yeah, go ahead.
I was just going to quickly add, I certainly agree, especially when, the intent behind these laws are just exceedingly clear, and they're just, meant to be a tool to limit the voices of, Black communities in particular, but also other non-white communities.
Sure. And I think this is going to be the last question we have time for, and this goes to Fred Brewington regarding the Islip case. And it asks, what was the motion practice before you went to trial? I'm curious why the town took it all the way to trial instead of settling after the 12B6 or motion for summary judgment got denied?
Well, therein lies an assumption. There's an assumption that there was a 12B motion or a Rule 56 motion. There was not. There was much motion practice. The motion practice was very interesting. We moved as plaintiffs for a preliminary injunction and had a full hearing. That helped lay the foundation for the trial. That we proved all of the first three preconditions, but didn't fill out all the Senate factors, the other items that we wanted to fill out. Through that decision, we got a roadmap on what we needed to do for trial. So that's one. But there were motions. They made a motion to recuse, to have the judge recuse himself because a new judge came on, and that was not a good move. One thing you don't want to do is piss the judge off. And in this situation, that certainly was not in their favor. And there were motions in limine. One of the most interesting points, motions in limine, and I'll just do this very quickly. They made a motion to have evidence put in about future demographics that were going to take place in Islip, to show that if we just wait 10 years or so, the Islip Latino community will be so large that they won't have any reason to think that they'll be outvoted. That was a slap in the face to the community, but also under voting rights law, we don't deal with things that are prospective or things that are going to happen. It deals with the reality in the community at the time that the case is being brought. So the motion practice was very interesting, but there was no 12B and there was no Rule 56 motion. When we got to trial, it was all hands on deck.
Thank you all very much. I think that's all that we have time for. All of those presentations were terrific, and I know I learned a lot of things I didn't know, and I'm sure our students in our audience did too. So thank you very much. Much appreciated.
Good.